Imagine being a popular rapper, but finding yourself in a breach of contract case. That's right. Contracts are everywhere, even in the glitzy world of showbiz. In 2011, Tramer Dillard was sued by an Australian festival organizer for failing to perform at the Fat as Butter Music Festival, despite having been paid a staggering $55,000. Now, you might be wondering, how does this relate to contracts? Well, it's simple. The agreement between the artist and the festival organizer was a contract, a legally binding agreement that outlines the obligations of each party. And when one party fails to uphold their end of the deal, they're said to be in breach of that contract. So, what was this case all about? And more importantly, what can we learn about contracts from it? Contracts are agreements made between two or more parties that create mutual legal obligations. They are the lifeblood of commerce, the backbone of business transactions, and the invisible hand that guides the market. But what exactly is a contract? At the most basic level, a contract is a binding agreement between two or more entities. It could be between two individuals, between a company and an employee, between two corporations, or even between a government and a private entity. Contracts are essential because they provide a framework for understanding and managing expectations. They outline what each party must do, when they must do it, and what happens if they fail to meet their obligations. They provide a sense of security and predictability, which is critical in business. To illustrate the power and significance of contracts, let's consider a recent case. Elon Musk, the CEO of SpaceX, accused OpenAI, a research organization he co-founded, of deviating from their founding agreement. In essence, he claimed that OpenAI had violated their contract. This case underscores the importance of contracts as tools for accountability. They define the rules of the game, and when someone deviates from those rules, they can be held accountable. It's worth noting that contracts are not just for the rich and powerful. They are for everyone. Whether you're buying a car, renting an apartment, or starting a job, you're likely to encounter a contract. So understanding contracts, how they're structured, and what they're meant to do is a skill that everyone can benefit from. Contracts also play a vital role in maintaining order in business transactions. They provide a framework for resolving disputes and ensuring fairness. If a dispute arises, parties can turn to the contract to see what was agreed upon and how the situation should be resolved. So, how do we know what a contract should include and how it should be enforced? That brings us to the sources of contract law. There are two main sources of contract law: common law and the Uniform Commercial Code. Now let's delve into what exactly these are, their origins, and how they apply to contracts. First, we have common law. This is a body of law developed by judges, courts, and similar tribunals as they issue rulings on legal disputes. These rulings become case law, which sets precedent for future cases. Common law is often referred to as judge-made law, and it forms a significant part of the legal system in many English-speaking countries, including the United States, United Kingdom, and Canada. In the context of contracts, common law governs contracts related to services, real estate, insurance, intangible assets, and employment. Next, let's turn our attention to the Uniform Commercial Code, or UCC for short. The UCC is a comprehensive set of laws governing all commercial transactions in the United States. It was first published in 1952 and has been adopted in some form by nearly every state. The UCC aims to harmonize the law of sales and other commercial transactions across the U.S., making it easier for companies to conduct business. Unlike common law, the UCC covers contracts related to the sale of goods. So, to put it simply, if you're dealing with a contract for the sale of a car, the UCC would apply. But if you're negotiating an employment contract, you'd be looking at common law. But remember, both common law and the UCC aim to ensure fairness and predictability in contracts. They provide a framework for deciding disputes and interpreting contractual terms, all while aiming to uphold the principle of pacta sunt servanda, a Latin phrase meaning agreements must be kept. Now that we've covered the sources of contract law, let's move on to the elements of a contract. For a contract to be valid, it must have certain elements: agreement, mutual consideration, performance, legal capacity, and enforceability. Let's start with the first element, agreement. This is the meeting of minds, the point at which both parties reach a common understanding. It's like a dance. One party makes an offer, and the other accepts. A simple yes can form the basis of an agreement. But remember, an agreement alone doesn't make a contract. Next, we have mutual consideration. In the world of contracts, consideration is essentially the price paid for the other's promise. It can be anything of value: money, goods, services, or even a promise to do something. The key here is mutual exchange. Both parties must give and receive something of value. The third element is performance. Once an agreement is in place and consideration has been exchanged, the parties must perform their obligations under the contract. If one party fails to perform, it can be considered a breach of contract. But it's not always as black and white as it seems, and sometimes non-performance can be justified. The fourth element is legal capacity. This refers to the ability of a party to enter into a contract. Certain individuals, like minors or those deemed mentally incompetent, lack legal capacity. If a party lacks capacity, the contract could be deemed void or voidable. And finally, we have enforceability. This means that the contract must be capable of being enforced in a court of law. For a contract to be enforceable, it must be clear, definite, and certain. Additionally, the contract must not be for an illegal purpose or against public policy. Remember, all these elements must be present for a contract to be valid. If even one is missing, the entire contract could be in jeopardy. It's like a puzzle. Each piece plays a crucial role in completing the picture. With the elements in place, we can now differentiate types of contracts. Contracts come in various types, each with its unique characteristics. Let's dive into some of these types and see how they differ from one another, starting with an express contract. This is a contract whose terms are spelled out directly and explicitly. The parties involved state the terms and conditions openly and directly, leaving nothing implied or inferred. For instance, a written lease for an apartment is an express contract with the terms and conditions outlined in detail. On the flip side, we have implied contracts. These are a bit trickier because they are not explicitly stated. Instead, they are inferred from the actions, conduct, or circumstances of the parties involved. For instance, when you sit down at a restaurant and order a meal, you're entering into an implied contract. You're implying that you'll pay for the services rendered, and the restaurant implies they'll provide a meal. Now let's discuss valid, void, and unenforceable contracts. A valid contract is a fully functional, legally binding agreement. It contains all the necessary elements of a contract we've discussed earlier. In contrast, a void contract is essentially a non-contract. It lacks one or more of the essential elements, making it not legally enforceable. For example, a contract for illegal activities would be void. An unenforceable contract, while it may appear valid and includes all necessary elements, cannot be enforced due to some legal technicalities. For instance, a contract that needs to be in writing but isn't falls into this category. Next up, we have unilateral and bilateral contracts. A unilateral contract is a one-sided agreement where one party promises to do something in return for an act of the other party. An example would be a reward contract. You lost your dog, You offer a reward, someone finds the dog and claims the reward. A bilateral contract, on the other hand, is a two-sided agreement where both parties make promises to each other. Like when you buy a car, you promise to pay the dealer, and they promise to deliver the car. Last but not least, we have executory and executed contracts. An executory contract is one where the terms of the agreement have not been fully met by all parties. It's a contract in progress. An executed contract, however, is one where all parties have fulfilled their obligations. So, let's say you ordered a custom-made suit. The contract becomes executory when you pay but haven't received the suit. Once you receive your suit, it becomes an executed contract. Understanding these contracts helps in identifying and dealing with them appropriately. Remember, the world of contracts is vast and complex, but with a solid grasp of the basics, you're well on your way to navigating it confidently. One integral part of any contract is the offer. But what exactly does an offer entail? An offer in the realm of contracts is a clear, definite, and explicit proposal presented with the intention that, if accepted, it will culminate into a binding contract. It's like extending an invitation to someone to enter into an agreement. Sounds straightforward? Well, there's a bit more to it. There are 3 essential elements that an offer must possess to be legally valid. Let's dive into them. First up is intention. The person making the offer, known as the offerer, must have a serious intention to become bound by the offer. This is judged objectively, meaning we look at whether a reasonable person would conclude that the offer intended to be bound. The second element is certainty and definiteness. The terms of the offer must be clear and specific. For instance, if Elon Musk were to offer you a job at SpaceX, but didn't mention the position, the salary, or the start date, that's not a definite offer, right? The terms are too vague, leaving too much room for interpretation. The third and final element is communication. The offer must be communicated to the offeree, the person to whom the offer is made. An offer that isn't communicated is like a tree falling in a forest with no one around to hear it. Does it make a sound? Maybe. But is it an offer? Definitely not. So, there you have it. The offer in a contract is not just about throwing out a proposal. It's about having the intention to be bound by it, making sure the terms are clear and specific, and communicating it to the right person. So, the next time you make an offer, remember these 3 elements. It might just save you from ending up in a legal tangle, or worse, a contract you didn't mean to enter into.